Major breaking news. In the United States Supreme Court, a major reply brief has been filed on behalf of the Bianchi plaintiffs in the assault weapon ban case that is going before the U.S. Supreme Court of Bianchi versus Bruen. This is up on a request for cert. Specifically, the Bianchi plaintiffs, in support of the Second Amendment, are asking the U.S. Supreme Court to hear the case that claims that the quote-unquote assault weapon ban of semi-automatic rifles by the state of Maryland is unconstitutional under the Second Amendment. We're going to talk about this major filing right now and what it means for your rights in the Supreme Court coming up very soon. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and author of Disarm: What the Ukraine War Teaches Americans About the Right to Bear Arms. All right, folks, just as a reminder, there are two main pending quote-unquote assault weapon cases pending before the U.S. Supreme Court. They're both up on request for cert, which means the Supreme Court has to decide whether or not to hear these cases. And by cases, I mean there is the Bianchi versus Bruen case, which is a challenge out of the state of Maryland. It's a challenge to Maryland's quote-unquote assault weapon ban. It is a ban of AR-15 style semi-automatic rifles. That is the Bianchi case. There's also sort of a group or a gestalt of cases that have arisen out of Illinois and some cities there, also pending before the U.S. Supreme Court, challenges to the recent laws, assault weapon bans and magazine bans from the state of Illinois. The procedural posture difference between the Bianchi case out of Maryland and the Illinois cases is that the Illinois cases have not achieved a final judgment. Those are all what is known as on an interlocutory basis or an interlocutory procedural posture, which means the cases are still going on. There is no final judgment. It's not final yet out of Illinois. In contrast, the Bianchi case does have a final judgment against the Second Amendment plaintiffs that the U.S. Court of Appeals has previously upheld before Bruen. And of course, that was recently argued before the U.S. Court of Appeals for the Fourth Circuit. But the Bianchi plaintiffs in support of the Second Amendment are essentially claiming, and rightly so in my opinion, that the Fourth Circuit Court of Appeals is playing games and dragging their feet and trying to avoid ruling on this case. And it's appropriate for the U.S. Supreme Court to intervene and finally settle once and for all. Again, this has already been settled once and for all with Heller and then Bruen, but to really make clear once and for all with these inferior judges, these inferior courts, these lower courts that are engaged in a massive resistance in the same way we saw southern states doing that and trying to avoid desegregation in the 1950s. It's up to the U.S. Supreme Court to step up. So the major brief was filed. This is the last major brief to be filed before the U.S. Supreme Court will conference the Bianchi quote-unquote assault weapon case. By conference, I mean they will sit down and they will vote as to whether or not to take the case. So this is a major legal filing on behalf of the Second Amendment. So let me, first of all, summarize the essence of the argument by the Second Amendment plaintiffs, which we are, of course, cheering for because we really want the Supreme Court to take this case. If they take this case, we, in my view, have a 99.9% chance of absolutely winning this case. It should be a very easy case, but we need the Supreme Court to take it. So let's start off with exactly what they're arguing as to why the Supreme Court should take this critical assault weapon case out of Maryland. The Second Amendment petitioners agree with Maryland that this court's decision in Bruen left Heller undisturbed. But that fact undermines Maryland's opposition. With respect to timing, this court decided Heller in 2008, which refutes the argument that it is premature to address the question whether state bans on common semi-automatic rifles are consistent with the Second Amendment. With respect to the merits, a straightforward application of Heller demonstrates that Maryland's ban is unconstitutional. As Heller holds and Bruen repeatedly confirms, law-abiding citizens have an absolute right to possess firearms that are in common use for lawful purposes. And there can be no question that the rifles Maryland bans are in common use. Indeed, they include the most popular rifles in the history of the nation. Powerful language in support of asking the U.S. Supreme Court to hear the Bianchi case. Keep in mind that Maryland's opposition, the anti-gun opposition, was essentially that it was premature for the Supreme Court to hear this case because the issue is still percolating. They're still discussing. They need to have dialogue and other considerations and maybe more factual finding, all this kind of excuse to delay, deny the reality on the ground, which is the Heller in common use test is a sufficient way to win. And since we're talking about AR-15s and the most popular semi-automatic rifles in American history, these are easy cases to decide. And here's what the Bianchi plaintiffs argue again in support of the Second Amendment, why the U.S. Supreme Court should take this case. They write the following. To be sure, granting certiorari before judgment is not typical, but neither is the sua sponte seizure of this case by the en banc Fourth Circuit 13 months after argument, nor is the continued incapacity of lower courts to grasp the plain teaching of Heller in this context. This court should grant certiorari to make more explicit what should have been apparent with the issuance of Heller in 2008, that the government simply lacks the authority to ban commonly possessed arms. Powerful language there and completely correct. The Heller case, the in common use test is clearly the right answer. Bruen did not alter any of this. In fact, I think there's some very powerful points that should be made about how Bruen reaffirms Heller. I write about this in the Harvard Journal of Law and Public Policy. I'll put the article down below, but to make it really easy, there's two passages, at least two passages in Bruen that I'll quote in just one second, that really shows that there are 6 justices. Do you hear what I just said? I believe there are 6 justices on the 9-justice Supreme Court that 100% will agree that these AR-15 semi-automatic rifles are protected arms. All you need to do is look at the Bruen decision in a couple critical passages to see that the 6 justices that wrote the majority or signed off on the majority in Serpa versus Bruen clearly understand that the in common use test is the test when you're dealing with arms ban cases. Let's turn to the record and see what I'm talking about. It is undisputed that petitioners Koch and Nash, 2 ordinary law-abiding adult citizens, are part of the people whom the Second Amendment protects. Nor does any party dispute that handguns are weapons in common use today for self-defense. We therefore turn to whether the plain text of the Second Amendment protects Koch's and Nash's proposed course of conduct, carrying handguns publicly for self-defense. Now, the critical line there is that nor does any party dispute that handguns are weapons in common use today for self-defense. That language is showing you that there is no debate that handguns are in common use and therefore they're protected. So they just said, yeah, we understand there's no dispute. So we're going to get to the question of what does the right to bear mean, i.e. the right to bear, does it include the right to carry guns outside the home for self-defense? Now also the reason why they were talking about self-defense in Bruen was a very specific reason. It wasn't that the in common use test is limited to self-defense. This is a game that the anti-gunners try to play. They try to say that a gun has to be in common use for self-defense as opposed to what Heller says, which is in common use for all lawful purposes. The reason why they use the phrase in self-defense in the Bruen case is what was the issue presented in Bruen. Well, the plaintiffs in Bruen that were challenging New York's law already had the right to hunt. They could carry the gun for all sorts of other reasons, if you recall. The one thing they were not allowed to do was to carry their handguns in public for the purposes of self-defense on a daily basis because they were not deemed special enough or important enough in New York to be able to carry guns for the purpose of self-defense. That's why the Supreme Court in Bruen talks all about the right to bear arms in the context of self-defense, because that was the specific issue, the specific remedy that the plaintiffs in Serpa versus Bruen were seeking. And that's it. It wasn't that Bruen modifies the in common use test, as in the in common use by Americans for all lawful purposes, and narrowed it to in common use by Americans for self-defense purposes. That's not what happened at all in Bruen. Bruen was just talking about self-defense because it was the specific issue presented by those particular plaintiffs in that case, because they specifically wanted to carry guns for self-defense outside the home. And the Supreme Court says, of course, they could. So again, that language there indicates clearly that the 6 justices thought Handguns were in common use, therefore they were protected, period, full stop. But there's more. Let's check out this next discussion in Bruen itself, where they're reaffirming Heller and specifically pointing out that, again, they understand that guns that are in common use cannot be banned, period, full stop. Regardless, even if New York's reading of these colonial statutes were correct, it would still do little to support restrictions on the public carry of handguns today. At most, New York, that's respondents, can show that colonial legislatures sometimes prohibited the carrying of dangerous and unusual weapons, a fact we already acknowledged in Heller. Drawing from this historical tradition, we explained that the Second Amendment protects only the carrying of weapons that are those in common use at the time, as opposed to those that are highly unusual in society. Whatever the likelihood that handguns were considered dangerous and unusual during the colonial period, they are indisputably in common use for self-defense today. They are, in fact, the quintessential self-defense weapon. Thus, even if these colonial laws prohibited the carrying of handguns because they were considered dangerous and unusual weapons in the 1690s, they provide no justification for laws restricting the public carry of weapons that are unquestionably in common use today. Powerful language there. Now, that is the Supreme Court in Bruen, but you can see that Bruen is really just reaffirming, and they're citing every step of the way to Heller. Okay? So again, it's clear that the Supreme Court has already decided that, again, if weapons are in common use by Americans for lawful purposes, they cannot be banned. And that is exactly what Maryland is doing here. And there is no need for further discovery. There's no need for more experts. There's no need for more research. There's no need for more analysis. There's no need for more percolation among the judges to figure this out. That's all total BS. And I'm sure the U.S. Supreme Court knows this. The question is, will the Supreme Court take this case or not? That I can't speak to. There's a lot of considerations we can get into in other videos. But the bottom line is, very powerful submission today. I'll put a link to it down below on behalf of the Second Amendment plaintiffs in the Bianchi versus Brown case arising out of Maryland. I think, again, based on what I just read to you, we have 6 votes. No shock. That says we have the right to keep and bear arms, and that includes all firearms in common use today. And of course, that would include not just semi-automatic rifles such as AR-15 platform firearms or AK-47 style firearms, but also magazines that hold more than 10 rounds. But the Bianchi case out of Maryland is specific to firearms. It doesn't deal with magazines. The Illinois cases do deal with magazines and semi-automatic rifles. But again, that's where we are. So check out the brief submitted in the Bianchi versus Brown case. Very powerful stuff. And I hope you'll learn something here today. Make sure you follow me on X at @4boxesdiner. And please subscribe and resubscribe and encourage people to subscribe to this channel. That will really help me out with the algorithm. We're working hard trying to spread the word. We're trying to get to at least 150,000 subscribers. I know we're very far behind everyone else, but we are working hard to catch up. So there you have it. And thanks for joining us. And we will see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.